Thanks, Paul. I'm going to throw some challenges to the room. I mean, we've heard some interesting ideas around solutions and trends. I'm afraid the trend from the legal perspective is perhaps not great, and I'll explain why. The law is playing catch-up with this particular issue, and that's because in the past, the European regulators have really focused on how you serve ads from a technological perspective and regulating around that rather than outcomes. And if you're regulating technology, the problem is for the regulators, the technology is doing that, and lawyers are a lot slower to react to the technology. So you end up with this disconnect between where technology is going and people, as far as the regulators are concerned, circumventing the rules and law being able to respond to that. So what is coming over the horizon? Well, there are two key regulations. One of them has already been mentioned this morning, but the most important one is this one, rather than the GDPR. The GDPR, think of the GDPR as regulating more the relevancy of the advertising by creating profiles of individuals and making sure that the ad that you're serving is relevant. This regulation, which is under review, looks at the means by which you serve up that advertising. So this is an example of where historically the law has actually regulated the technology, and the key technology here, of course, is cookies. And it is under review. And required reading, I think, for anyone who's interested in this area, and particularly the law in this area and how it's developing, is the European Data Protection Supervisor's opinion about what this new law, the revamp of this law, should look like. Because, frankly, it's quite scary in terms of your existing business models and how you're going to have to adapt those business models to reflect the way that the regulators are thinking about this area. But with scariness comes opportunities, and I'll come back to that in a second. The other piece of legislation, GDPR, hopefully everyone is aware of this, and Brexit is not going to impact on the implementation of GDPR. That's now been made very clear by the government. No surprise to lawyers, but perhaps a surprise to people who voted leave. Who are the regulators? Well, we've got a new privacy regulator in the UK, Elizabeth Denham, another Canadian. Canadians seem to be taking over key parts of the UK establishment. We've got, of course, the Governor of Bank of England, who's a Canadian. Elizabeth Denham, interesting. Previously, we had Chris Graham heading up the ICO, who I think took a fairly softly approach, although not really the case towards the end, where there was quite a lot of enforcement by the ICO around cold calling. Elizabeth Denham, I think, is a completely different proposition. I think we're going to see quite an interventionist regulator going forward. She has already made a couple of public speeches which do not pull any punches in terms of how important she sees her role going forward and how important privacy is as a social and economic issue. From a European perspective, we've got currently the Article 29 Working Party. That is going to be replaced by something called the European Data Protection Board. And I think the key takeaway for you there is that there's going to be far more cooperation across the various territories in Europe around enforcement. The GDPR promotes harmonisation of the rules, but the problem you have is that you can't just look at the rules being harmonised, it's how they're enforced as well that is important. And historically, the same rule in two different countries has been enforced in entirely different ways. The role of the board is to try and promote more consistency around enforcement. So what will change? Well, certainly the scope of the type of data that is subject to regulation is going to change. It's much, much wider than traditional notions of personally identifiable information. So, for example, anonymized profile data is going to be subject to regulation. That's a big change. Processing activities are also going to be regulated for the first time, and the key one is profiling. Profiling itself is going to be a regulated activity where you either have to provide information to the user that you're doing it, and in some circumstances, although we're not sure at the moment yet, you would actually have to get an explicit consent to actually conduct that profiling. So that's a big, big change, and it's certainly, from my discussions with the ICO and across Europe, this is going to be a real focus for them post-implementation of GDPR. So what is going to change beyond those two things? Well, more rights being granted to users. Now, I put more in quotes because in actual fact, you could argue that all we're doing is really enhancing much of the rights that currently individuals have in relation to their data. There are some new rights. Data portability is a new right, but the right to be forgotten, for example, which has received a lot of press coverage, that's really an enhancement of the current right to object. So it's more evolutionary than revolutionary. But the emphasis for the regulators, and I think this is what starts to pose a challenge for the publishing industry and ad blockers and the use of them, and anti-blockers, is providing users with more control and choice. That is really the underpin of what these new regulatory changes are seeking to achieve. And you're going to need to be more transparent about both user rights, but also what I would call the what, why, how, and where of data. What are you processing? Where do you get it from? Who do you share it with? And for what purposes? The regulators want more transparency, but as we all know, in the ad targeting infrastructure, the ecosystem, there is a distinct lack of transparency, even down to the level of course, publishers, where certain publishers sometimes are not even aware that cookies are being dropped on their own site. So there's some work to be done there around transparency. The European Data Protection Supervisor, who's an Italian chap called Mr. Buttarelli, released his opinion on PECA, which I mentioned earlier. And one of the things that is discussed in that paper is whether cookie walls should be completely prohibited. That's certainly his preferred option. I suspect we won't end up in that position, but what we will end up with, I suspect, is a situation where, as a publisher, you are going to have to provide your users with a real choice. And if you have an ad-funded model, you are going to have to provide possibly a subscription-based model, so that people do have the choice, so they can take the ads, but they have to accept what the regulators, basically, their view is it's intrusive technology. That's how they see it. I mean, that's why I think for the industry, looking at that opinion, you may disagree with what Buttarelli says in there, but it gives you an insight into the minds of the European regulators in terms of how they see this whole debate. And it is primarily, for them, about empowering the user. So if you deploy anti-ad blocking, as far as they're concerned, that is impinging on the user's freedom to choose to deploy ad blocking. That's how they see it. So that's the challenge, is how do you get around that mindset? So what are the outcomes? Well, I think there is going to have to be a significant recalibration of the data value exchange. It's going to be about incentivizing users to go down that ad-funded approach with more relevant advertising, giving users value, choice. And so in terms of a vocabulary, if you've got transparency with control that you have to provide the user about their ability to switch things on and off, that means that you also then have to promote choice. You need to provide value to individuals, promote trust, and incentivize behavior. Moving away from, and it's a loaded term, but again, one used by the regulators, where users are compelled to accept something. That, as far as Europe is concerned, is not a runner in terms of a legislative framework. That's all I wanted to say.